Hello, and thanks for watching this short video on topical workplace discrimination issues. My name is Chris Dobbs. I'm an employment solicitor here at Frettons. This video was recorded in September 2021 following our first in-person HR forum since the start of the pandemic, where we recap the key provisions of the Equality Act and discuss some recent case law updates. The purpose of this video is to share the discussion points and legal issues raised during that session for anyone who was unable to attend the live event. If you might be interested in attending future events or want to explore the other training options we might have available, please do get in touch or take a look at the employment section of our website. So, starting with some key provisions of the Equality Act, the 8 protected characteristics should not come as a surprise to anyone, since this legislation has been around since 2010. These are the 8 traits from which detrimental action can give rise to claims for discrimination against an employer. Age claims are slightly unusual in that they can be quite difficult to prove. The most commonly arising age claims really come from redundancy or capability processes where selection criteria or indicators for performance can be unfavorable to older employees. They also crop up in recruitment practices where older or younger staff may be deliberately targeted by a recruitment campaign. Age is unique as a protected characteristic in that even direct discrimination can be lawful if it's justifiable. Disability claims are among the most common in the employment tribunal, and disputes are often around the definition and whether a claimant actually satisfies all of the necessary tests. More on this will follow in some of the case studies that we explored as part of the session, but contemporary issues with disability include the point at which mental health conditions satisfy the test, the as yet relatively unknown entity of long COVID, and issues around whether the menopause or at least its symptoms can qualify. The most recent change in respect of gender reassignment was the Taylor and Jaguar Land Rover case. This was a first instance tribunal decision which ruled that process for the purposes of Section 7 can be any step taken by an individual to identify as other than their natal or birth gender. This therefore includes a change in dress, in appearance, name, or pronouns of choice. In effect, this means that fluid and non-binary gender identities should be considered as falling within this definition. Marriage and civil partnership cases are exceptionally rare. One did reach the Court of Appeal last year, having made its way through the system since about 2016. But, as with many of these cases, the issue was really whether or not marriage was the cause of the detriment suffered, which can be very hard to prove. The important thing to remember here is that what's protected is the state of being married or in a civil partnership. It's not the lack thereof. So single people, cohabiting couples, and divorcees are not in fact protected. Race claims are probably one of the most established in this list and arguably one of the ones that people are most wary of. Direct race claims are increasingly rare, and race claims usually only either arise due to cultural insensitivity, a lack of awareness, or badly managed harassment claims, which become something more serious. Religion and belief have changed a little bit in the last few years. Originally, religion and belief protection was seen as a way of protecting from discrimination, people of different faiths and with strong non-religious belief systems. Since then, we've seen it extended to issues involving fox hunting, political persuasions, and of course, most recently and famously, ethical veganism. Other current cases include matters around the trans identity debates, and religion or belief is increasingly becoming tied to freedom of speech and other human rights issues. Sex discrimination claims are also now increasingly rare, at least in the traditional sense. Although, of course, we are still seeing equal pay claims and some recent cases about dress codes. The most common claims in connection with sex discrimination at the moment are either related to working hours and flexible or hybrid working, where it was recently held that women can still be said to have a greater share of the so-called childcare disparity, or claims in respect to the menopause. Finally, sexual orientation claims are also quite rare. Much like race and sex claims, direct discrimination is very unusual, and so these claims tend to stem from allegations of harassment which are then handled badly or insensitively, which then escalate. That's a very brief exploration of the protected characteristics themselves. We did also spend some time looking at actual prohibited conduct. As we know, these are the forms of discrimination which exist under the Equality Act, and they are direct discrimination, this being very literally treating someone differently and less favourably because of their protected characteristic. What we think of as classic racism, sexism, all fall within this definition. Direct discrimination cannot be justified in law except in the case of age, and in a very specific number of circumstances where the need to discriminate arises from a genuine occupational requirement. Discrimination arising from a disability, which later in this presentation we referred to as Section 15, simply to shorten it, is a specific disability-related claim. It operates a lot like indirect discrimination, and the basic idea is that an individual who is put to a detriment is done so not necessarily because of their disability, but because of something connected to it, such as a side effect of medication, or because of the consequences of a symptom. We often see this claim where a sickness absence policy is overzealously applied for absence related to a disability, for example. The benefit of this claim for a claimant over an indirect discrimination claim is that for a Section 15 claim, they don't have to show a comparator. Pregnancy-related claims. Pregnancy isn't technically a protected characteristic in its own right. Discrimination claims arising from pregnancy are often brought under sex discrimination. What the Equality Act does do is set out things which can't be done when in connection with a woman who is pregnant or on maternity leave. The full scope of these is really outside the remit of this video, but we can broadly think of it as direct discrimination claims which are in connection with pregnancy or maternity. Indirect discrimination, as we alluded to talking about the Section 15 claim, is where you have a policy which applies apparently equally to everyone, all employees, but is particularly and adversely effective on those with a protected characteristic. Inflexible working hours or a requirement to work on certain days might indirectly discriminate against women or those of particular faiths, for example. Indirect claims can be justified where the effect of the discrimination is considered reasonable in the employer's attempts to achieve a legitimate business aim. Failure to make reasonable adjustments is again a specific disability-related claim. Classically, this is physical amendments to the workplace, changing hours, environment, the nature of the work, etc. But it can also mean adapting procedures and processes. That's particularly important when considering mental health as the disability. The test is one of reasonableness to the particular employer in question, and that means that those with larger resources are more likely to be expected to do more to make reasonable adjustments. Finally, we have harassment and victimization. These are both words which appear in almost every grievance. They are often used correctly if you look up the dictionary definition, but that's not the same as the legal definition. Harassment is any unwanted conduct which is connected to a protected characteristic and has the effect or purpose of violating dignity or creating a hostile, intimidating, etc. environment for a particular individual. The important thing to remember with harassment is that it says connected to a characteristic. The individual complaining does not necessarily need to have the characteristic in order to bring a claim. A straight man, for example, who faces homophobic taunts can still bring a claim on the basis of orientation. Victimization is equally specific and arises where someone is placed to a detriment because they raised a complaint of a breach under this Act, under the Equality Act. It also exists for someone who suffers a detriment because they've supported someone else in bringing a claim or raising a complaint. So the classic situation where this would crop up is an employee who remains with a business but gives evidence in support of a claimant who is later badly treated at work or even dismissed. That sort of explores the key provisions of the Equality Acts in terms of their immediate relevance in the workplace. What we then did as part of the in-person session was start to look at some of the cases over the last year or so which have tackled issues around discrimination. The first of these looked at the definition of a disability and the meaning of the word substantial within Section 6. In this case, the claimant was discovered during a disciplinary process to be on the autism spectrum disorder. He had Asperger's. The original judge noted with the comments on the screen there that the claimant struggled to speak in public, but but this is something that many people struggle with and therefore concluded that the claimant did not meet the definition of a disability. It was an interesting decision, which the EAT said was wrong, and that the original judge had misapplied the law. A disability is about the impact of the condition and the impairments on the claimant. To use a more extreme example, a great many people would struggle to run a marathon. I know I would. That doesn't mean that someone in a wheelchair is not disabled, simply because they would also struggle to run a marathon. The EAT also pointed out in its judgment that the Equality Act has a statutory definition of substantial for the purposes of Section 6, which gives a much broader meaning than perhaps we would use in everyday life. In our next case, the tribunal had to deal with the question of when someone becomes disabled. The claimants in this case alleged discrimination on the 21st and 22nd of August 2018, at which point the respondent accepted that they had an impairment, but not that it had or was likely to last 12 months. That's the definition used for long term. The tribunal considered evidence not only from the time, but also from between August 2018 and the date of the hearing in October 2019. They concluded that the condition must have been likely to last 12 months because it had done, and therefore the claimant satisfied the definition of a disability. Somehow the EAT agreed with this finding. They said the judge was right to consider evidence even where it post-dated the events complained about. The respondent, quite expectedly, appealed to the Court of Appeal, who finally made the point that someone is only discriminated against if they have the protected characteristic at the time of the alleged event. In the case of disability in particular, this means satisfying the full definition of the test at the time of the alleged discriminatory act. Our third case study looked at a reasonably well publicised case of two advertising executives who claimed various forms of discrimination after they were selected for redundancy, following the fact that they themselves raised concerns about language used by a senior director in a diversity drive. They alleged that they'd been selected for redundancy unfairly and in a discriminatory way after noting the apparent objective of obliterating the business's white, male, privileged British image was problematic to them and suggested forms of positive discrimination. They raised concerns that their own job security was in question. They were successful for their claims in discrimination on the basis of sex, for victimisation, and for unfair dismissal. What's interesting is that the tribunal noted its concern that sex was clearly a driving factor in the decision-making process, which therefore made it discriminatory. However, they also said that the basic objectives were not entirely unfounded. The company had a very poor set of diversity statistics, and the tribunal acknowledged the underlying aims of improving diversity as being worthy. However, as this was directly discriminatory in nature and the decision to dismiss was clearly connected to the claimant's sex, it could not be justified in law. Our final case looked at the potential cost of getting discrimination wrong in the ET. This case was incredibly unusual in that having dismissed the claimant for behaviour and conduct reasons, which emerged after he started taking steroids for an unknown condition, the employer was subsequently notified that the condition was actually cancer. The employee's solicitor had written to them and notified them of this. For some unknown reason, rather than maintain the position that they did not know and assert that the dismissal was fair on the original basis, the company undertook an entirely new post-termination procedure and still concluded that dismissal was the outcome, only in this case for some other substantial reason. Funnily enough, the tribunal saw straight through this new procedure as a sham. And in making a financial award, they took into account the claimant's significant length of service, his future career prospects, especially in light of having a terminal medical condition, and made an award for aggravated damages. The total award was more than £2.5 million, and it's the second highest award ever made in a disability discrimination claim in the UK. Finally, it is worth considering the risk of discrimination claims which might arise in connection with hybrid working models. Both offering and rejecting requests for hybrid working does come with some risk of discrimination, and the best way to avoid these is to ensure that the reason someone wants or doesn't want to work in a particular manner is taken into account positively and with a view to factoring it into a positive decision-making process. There is a real risk of two-tiering in businesses where those able to work from home fall within one gender, age bracket, or race, for example, and those who can't fall within another. Hybrid working models are more beneficial to working mothers and to those with disabilities or caring commitments of their own, but it's important to note that hybrid working is not a substitute for childcare or for any form of paid care. The individual is still employed during their contracted hours to work for the business. Once implemented, it's then important to ensure that those working from home are not missing out on the advantages of in-person working, and that social interaction and especially promotions are considered and applied equally. Again, if you have predominantly individuals of a certain age, race, or gender working from home and they get overlooked for promotion, there could be a discrimination claim. As we've said there on the slide, direct discrimination claims are unlikely. We're much more likely to encounter indirect claims or those Section 15 discrimination arising from a disability claims, both of which can be justified. What this means is recording the reasons for any selection process carefully and ensuring that they meet a genuine business need if you're rejecting for potentially discriminatory reasons. I hope you found this video useful, whether you were able to attend our in-person event and just wanted to recap the key points, or you were unable to attend it and wanted to have some insight into what was discussed. Our next HR forum is planned at the moment to be in person on the 10th of November, so do keep an eye out for email notifications nearer the time. If you're not on our mailing list for events and updates, please do take a look at the employment section of the Freston's website or get in contact with either me or Paul. Our contact details are on the screen now. Thank you once again for taking the time to watch this video. I do hope that you found it useful.